Well, good morning, everyone. Hey, Keith, how are you doing this morning?
Good morning. I'm doing great.
Perfect. All right. Well, thank you, everyone, for joining us. For any that don't know me, I'm Myra with Administrators Advisory Group, and it's my pleasure to host today's webinar. This webinar will be recorded, so if you aren't comfortable with that, please go ahead and disconnect now. We're here for a crucial update on employment law, focusing on both federal and Florida specific changes. This is a vital area that touches on the core of our HR practices, compliance, and overall workplace environment. We're privileged to have Keith Hammond, our esteemed employment attorney, with us. Keith brings a wealth of knowledge and expertise in employment law, and will be guiding us through the latest legislative changes. He'll also discuss recent actions from key agencies like the EEOC, NLRB, and Department of Labor. If you have any questions, please type those in the chat. We will have a Q&A session at the end of the presentation, so we'll answer those questions then. Without further ado, Keith, I'll turn the floor over to you.
Great. Thank you, Myra. And it is a pleasure to be here as always. I am going to put the presentation up on the screen here, so bear with me for just a second while we do that. But as many of you know, we have been doing this presentation, this update, for many years now. Hopefully everybody can see the slideshow here, and if not, then Luann will let me know. But what we typically have done and are doing today is to update everybody.
I don't see the slideshow.
Yeah, it's not sharing yet.
There we go.
There we go.
Perfect. So what we will do today, what we've done in the past, has been basically to update everybody as to the significant changes in employment law that have taken place since the last time we met. And we did have an update last April. There have been a few developments that we will want to go over today. What we'll specifically go over will be the changes in federal law, the laws that apply to employers nationwide, as well as a Florida state-specific legislative update. We'll discuss what Florida laws have been enacted since the last time we met. We'll also go into what other state legislatures have been doing. Laws that don't necessarily apply to employees here in Florida, but as we have become more and more of a remote worker-based economy, the law has somewhat struggled to keep up with those changes. And I'll give you an example of what I mean. If you have a remote employee in New York or California, does that mean that New York or California law applies to them? The answer is sometimes yes and sometimes no. So I'll go over some of the more significant changes in state employment laws elsewhere, as well as to discuss some best practices if there is even a chance that you'll have remote workers in states such as the ones that we'll go over. I'll also go over an update on what the federal executive agencies are up to and what their enforcement priorities are. Those agencies would be the National Labor Relations Board, the U.S. Equal Employment Opportunity Commission, the Wage and Hour Division, and we'll talk a little bit about OSHA, as there have been a few key changes or more aggressive compliance provisions or strategies that OSHA has undertaken over the last year or two. In fact, I believe that we discussed some of those initiatives last year. Those have been built upon, so I can give you the update today. So let's kick things off with the federal legislative update. Just to recap what has taken place over the last couple of years under the current presidential administration, we saw from 2021 until early 2023 a number of federal workplace laws being passed and going into effect, including laws like the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act, the Speak Out Act, the Pregnant Workers Fairness Act, the Pump Act, as well as the implementation of a new I-9 form. We'll go over all of these just to recap them in just a moment, but here's where we are in 2024. You know, if you watch the news, listen to the news, or even if you don't, you're likely aware that 2024 is an election year and that we currently have a divided Congress. The Democrats have the majority in the Senate. The Republicans have the majority in the House of Representatives, both by very slim margins. And consequently, very little legislation has been passed this year or will be passed this year. In fact, you probably have not even heard of any workplace legislation being bandied about. And the reason why is because there really isn't any. You probably see in the news that the hot button items are things like providing funds to Ukraine or Israel, not changes to workplace laws. Nor do we foresee any major changes through the end of this current year for a variety of reasons, the divided Congress being one, but also traditionally in an election year, very little gets done. Neither party wants to necessarily take a position that might not be favorable to them come election day in November. So what we will likely see this year, and we already have, as we'll discuss in just a bit, including as recently as yesterday, there was a major EEOC development, is that any major changes will likely be initiated at the agency level, the agencies that report up to the executive office, the presidency, such as the NLRB, the EEOC, and the Department of Labor. So we are also in a holding pattern on a few things that we have discussed in the past. The two major items that we're still waiting for some agency action on would be, number one, non-compete agreements. In fact, I think we've been discussing this for not one, but two legislative updates that we've done in the last couple of years. When President Biden first came into office, one of the early announcements that his office made was that the Fair Trade Commission was directed by the Oval Office to engage in some rulemaking, to come up with a regulation regarding non-compete agreements. And specifically, the guidance that was provided by the White House was to evaluate whether non-compete agreements should be enforceable at all. Currently, the state of the law is that non-compete enforceability is basically decided by state law. And we have a hodgepodge of state laws that are out there that are certainly not uniform across the country and range from the spectrum of, I'll use California, our good friends out in California as an example. Non-competes are flat out illegal in California. In Florida, on the other hand, we have a statute that expressly states non-compete agreements are enforceable as long as the employer can show a number of different things, including but not limited to some legitimate business reason why they need to have the non-compete. They need to show that the restrictive covenant, the non-compete itself, is reasonably necessary to protect those legitimate business interests, et cetera, et cetera. So in a nutshell, we have 50 different rules regarding non-competes out there. And sometimes we even see races to the courthouse, depending on whether the employer is headquartered in a state such as Florida, which is relatively employer-friendly in enforcing non-competes, or California, or even Georgia, right next door to us. If you have remote workers in Georgia, the law regarding non-competes is far more favorable to the employee in Georgia than here. And what you might see from time to time is an employee who is violating a non-compete running to the courthouse in Georgia, asking the court to declare that the non-compete is unenforceable. So going back to what we're waiting for is we have a pretty clear idea as to what the Fair Trade Commission has been directed to do. They simply haven't done it yet. Will they do it this year? Honestly, your guess is as good as mine. Again, we're in an election year. There might be some disincentive to act upon this now. This might be an issue that gets buried until after the election. On the other hand, if the FTC does come out with a ruling, certainly you'll hear about it. You'll hear about it either from me, from Myra. If you sign up for any legal blasts via email from the bigger law firms. You'll probably hear it from them as well. You'll likely know. Certainly we'll advertise that. The other thing that we're waiting for, which we do expect some action on in the very near future, is that the Department of Labor is planning to issue a final rule on the white-collar overtime exemptions, and specifically what the minimum salary level should be for those. You'll recall that several years ago, there was discussion of the minimum salary threshold more than doubling, frankly, and it took up until the day before those regulations were to go into effect before a court declared them invalid for procedural reasons, frankly. And those never went into effect. Rather, what went into effect was a slight increase from roughly a $23,000 minimum salary requirement up to about a $36,000 or so, and I'm using nice round numbers here. The discussion presently is that that number could be, you know, as high as something in the 50s. It could be in the mid 40s. When and if the Department of Labor's Wage and Hour Division implements its final rule, that's something that we'll discuss as well. And frankly, I think Myra will probably discuss it with everybody the very next time she comes out for a meeting with you after the rule is published, because we'll want to make sure that, you know, all of our exempt people are truly exempt and we don't run into a violation in that regard. But we don't have the final rule yet. We can only guess as to what the final rule will say. And that's the same, frankly, as with the FTC. We just think that the Department of Labor rule will actually come out soon, whereas with the FTC, things are a little less certain. So what has passed since the last time we spoke, or even in the beginning of the administration here? Well, this was really one of the first. I know that we did discuss this the last time, but just to remind everybody, the Speak Out Act, which is the legal jargon is to the right here on the slide here. But to summarize what this particular law does, it prohibits employers from insisting upon confidentiality provisions in a pre-dispute settlement agreement regarding sexual harassment. So in other words, if somebody internally complains of sexual harassment and the two sides decide, you know, it's best that everybody goes their separate ways, here's some money, employee, on the way out the door, sign off on this general release and promise not to talk about this. Well, those agreements are no longer completely legal. We cannot have a non-disclosure or a non-disparagement clause when it comes to a pre-dispute settlement of a sexual harassment claim. Unfortunately, there are a couple of questions that are still unanswered, you know, a significant amount of time since this law went into effect. The primary one being, what does it mean when a dispute arises? You know, you can still demand confidentiality to settle a sexual harassment lawsuit. You can still demand confidentiality to settle a sexual harassment claim that's proceeded to the EEOC, we think, but we're not entirely sure. We don't know exactly what Congress meant when they said dispute. With reasonable confidence, I can tell you that if the matter has proceeded to a lawsuit, yes, a dispute has arisen. With the EEOC, I'm fairly certain, less than 99%, but more than 50%. But how about internally when an internal dispute arises? I'm doubtful. You know, if somebody merely complains internally, it does not appear that an employer could demand a non-disclosure or non-disparagement clause as part of a settlement agreement in that situation. Also, Congress passed, and this law went into effect in, I believe, late 2022 or early 2023, the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act. And again, this law is designed to prevent employers from covering up sexual harassment. You know, one way that sexual harassment might be quote unquote covered up would be to demand a confidentiality or non-disclosure provision. Another way would be to keep any sort of litigation out of the public eye by demanding that sexual harassment claims be sent to arbitration rather than litigated in the open forum of our federal or state judiciary. it is somewhat common for employers to have arbitration agreements with their employees that essentially require all claims, all disputes between the employer and the employee be brought up in arbitration. If an employee tries to file a claim in court, the employer has the ability to ask the court to send the case to arbitration, which does happen with some frequency. This particular law, though, says that employers cannot demand that sexual harassment claims be sent to arbitration. It does allow employees to agree, though, that sexual harassment claims can be sent to arbitration rather than litigated in the courts. If you have arbitration agreements and they haven't been reviewed or revised in the last couple of years, I strongly recommend that this is the time to do so. And specifically, what you would want to do is create some sort of carve-out pursuant to this particular law, stating that unless the employee consents to having their claim arbitrated, then sexual harassment claims are not covered by the arbitration agreement. A more aggressive approach might be to say, employee hereby consents to the arbitration of any disputes pertaining to sexual harassment. I think you're on the cutting edge there, but hey, some employers like to be on the cutting edge. But as long as you know full well ahead of time that that provision may ultimately not be enforceable, as it appears the employer might be heavy-handed in insisting upon that clause, then okay, hey, go for it and see if it is enforced, and if so, fantastic. Another law that went into effect actually right after we had our last update in June of 2023 is the Pregnant Workers Fairness Act. The Pregnant Workers Fairness Act is essentially another accommodation law. To kind of take the 30,000-foot view as to workplace law, employment law, one of the main segments of employment law are the anti-discrimination laws. Title VII, which prohibits discrimination on the basis of race, color, religion, national origin, and sex. The Age Discrimination in Employment Act, the Americans with Disabilities Act. And among all of those laws, there were two types of discrimination that the courts traditionally found, and Congress and the agencies later picked up on and regulated this. There were two protected classes where a form of discrimination would be not providing reasonable accommodations based on that protected characteristic. Those two were, of course, disability and religion. If you had a qualified individual with a disability who was in need of accommodation in order to perform the essential functions of the job, an employer would be required to provide that accommodation unless the accommodation amounted to an undue hardship. When it came to religion, employers were required to provide accommodations based on bona fide religious beliefs and practices, unless those accommodations constituted an undue hardship. The kind of textbook example would be an employee who's required to work on Saturdays or Sundays, yet is strictly religious, and the religious services are on Saturdays or Sundays. They ask for the Saturday or Sunday off. The employer refuses to provide that accommodation and ends up disciplining or terminating the employee after they no-call, no-show, or even if they do call and no-show on a Saturday or Sunday. And then litigation ensues as to whether or not that accommodation posed an undue hardship. Well, the bottom line to the Pregnant Workers Fairness Act is that Congress created a third means for failure to accommodate to amount to unlawful discrimination. And that would be if a pregnant employee, or even more broadly, a worker with known limitations related to pregnancy, childbirth, or related medical conditions needed an accommodation, the employer is now required to give them. The poster to the right was implemented or issued by the EEOC when the law first went into effect. It is very generalized. You can see it's only a one-sheet poster here, but basically it tells employees what their general rights are and, of course, what to do if the employer says no, call the EEOC, right? The EEOC also issued at the time some guidance for employers as to the types of reasonable accommodations that would be required. I will say, in hindsight, these were very generalized. I don't think that these are awfully controversial, but hey, allowing a worker to sit or to drink water because of a condition related to pregnancy, childbirth, or related medical condition. Give the employee a closer parking spot, allow flexible hours. The list is here on the left there, and I won't go through all of them, but it's a fairly common sense list of accommodations. Now, if you've ever dealt with an employee seeking an accommodation due to a disability that would require time off, unpaid time off, you will know that in some instances, providing that unpaid time off is a reasonable accommodation. Well, the same is true here under the Pregnant Workers Fairness Act. There could be instances where you'd be required to provide the accommodation of unpaid time off. There are a number of prohibitions as well. Employers cannot, for example, require an employee to accept an accommodation of the employer's choice without discussing that accommodation between the worker and the employer. This is actually a significant difference between the Pregnant Workers Fairness Act and the Americans with Disabilities Act. Under the ADA, employers are merely required to provide a reasonable accommodation that enables the employee to perform the essential functions of their job. The ADA does not require employers to provide the accommodation of the employee's choice. So if there are two potential accommodations that would enable the employee to perform the essential functions, and one, let's say, is more costly than the other, so the employer would prefer the less costly accommodation, even though the employee would prefer the more costly one, employers are complying with the ADA by providing the less costly accommodation. There's not an issue there. There could be an issue under the Pregnant Workers Fairness Act, particularly if there's no discussion with the employee about what accommodation the employer is willing to give. Additionally, and this would be true under the ADA or under Title VII's religious discrimination prohibition, it's illegal to deny a job or other employment opportunities to a qualified individual because of that person's need for a reasonable accommodation under the Pregnant Workers Fairness Act. Also, covered employers can't require employees to take leave if another reasonable accommodation can be provided that would let the employee keep working. Again, let me kind of compare this to the ADA. Under the ADA, you may, in many circumstances, be perfectly fine telling an employee, look, here's the accommodation we're going to give you. Instead of allowing you to come and go as you please because you have migraines, we're just going to put you on a leave of absence until the condition subsides. Likely perfectly okay under the ADA, not okay under the Pregnant Workers Fairness Act. You have to evaluate whether there is some lesser accommodation that would enable the employee to keep working. Of course, there's a non-retaliation provision, an anti-retaliation provision, just like the retaliation provisions under Title VII or the ADA or ADEA. You can't retaliate against somebody because they filed a charge or because they filed an internal complaint that they feel discriminated against or because they participated in an investigation being conducted by the company as to one of those types of complaints. And then finally, there's a component that's a bit like the FMLA, the Family and Medical Leave Act. Recall that the Family and Medical Leave Act basically enables employees to bring two types of claims. One would be what they call interference. The employer didn't give me what I was entitled to under the FMLA. I was entitled to 12 weeks of leave. They wouldn't let me take it. That's an interference claim. If you were to see a lawsuit, the name of the count, the claim would be interference. Likewise, the FMLA prohibits retaliation. So those are the two claims you can bring. Here, the Pregnant Workers Fairness Act provides for a claim of interference if an employer does not give the employee what they are entitled to under the act. Now, I mentioned earlier that there was action taken by the EEOC as recently as yesterday. And here's the exciting news, to the extent one considers EEOC regulations exciting. The EEOC yesterday announced that they will be publishing their final regulations pertaining to the Pregnant Workers Fairness Act this coming Friday. The unpublished version of the regulations were made available online yesterday. They are 400 plus pages long. I will confess, I did not get through all 400 pages of them. But once they are published, you'll probably be receiving, again, those emails from other law firms, summarizing here's what the key takeaways are. You'll likely hear from me or Myra as to what the key takeaways are. But it appears that maybe some of the more controversial, shall we say, provisions of the regulations would be to take an expansive view of who is covered under the Pregnant Workers Fairness Act, as well as what types of conditions and what types of related medical conditions or procedures might be covered under the Pregnant Workers Fairness Act. So stay tuned. You'll certainly get an update on what those requirements are. I think that everybody right now is digesting exactly what has been put online, and we're confident it'll be the same as what's published on Friday, but naturally we'll want to double check that as well. The Pump for Nursing Mothers Act also went into effect. As many of you likely know, if you had a nursing mother in the past, I believe it's about 8 or 10 years, you would be required in most instances to provide a place other than a restroom, shielded from public view and intrusion from coworkers, not a bathroom, to express breast milk. Well, there was a rather large exception to that previous rule, and the exception was if you were a white-collar exempt employee, executive, administrative, or professional employee, technically the previous law did not apply to you. You could be denied reasonable break time to express breast milk. So the Pump Act for Nursing Mothers was designed to close that loophole and essentially say that that class of employees was covered. It's illogical to exclude them or to punish them simply because they hold an exempt position rather than a non-exempt position. And then finally, I mentioned that there was a new I-9 form that has been implemented. Be mindful that the old form has expired, so don't use that anymore. It expired November 1st of 2023. If you're still using the old I-9 form, immediately after this presentation, just go online, type in I-9 form, and you'll be taken to the ICS, the Immigration and Customs Enforcement homepage, where they have this available on a PDF. The changes are not necessarily earth-shattering. I do think that the new form is a bit more streamlined and a little more user-friendly. You do not need to go back and correct any I-9 form that you've already done, but certainly be using this new form from here on out. Specifically, what the changes are, sections 1 and 2 of the form have been reduced to a single sheet of paper. It's just the first side of the first sheet of the I-9 form is now sections 1 and 2. Section 1 is the employee information. Section 2 is some information regarding the employer. The preparer or translator certification area is now a standalone supplement, which is nice because employers can use that standalone supplement for use for the initial verification or for recertification. And similarly, Section 3, which pertains to re-verification and rehire, is now its own standalone supplement form. So you only have to fill out one sheet of paper instead of having the entire form there. The list of acceptable documents, passport, driver's license, social security card, and then there are a whole lot of fairly obscure documents that are acceptable. The list on the form now has some guidance as to what's acceptable or what's not, as well as links. I'll give you an example of some of the more obscure documentation that's okay. If you have applied for, let's say, a new social security card because you recently were married and you're changing your last name, but the card hasn't been issued yet, it's okay to provide a receipt that you have gone to the Social Security Administration and this change is in progress. So although those situations don't arise frequently, it's somewhat nice that currently USCIS has put together a bit of information as to what is okay and what's not. Additionally, there are alternative remote verification procedures that employers who are enrolled in E-Verify can use to comply with their I-9 obligations. If you think back to when we were emerging from the pandemic, from the lockdown, and all of a sudden employers were faced with having to verify the I-9s for all of the people that they'd hired remotely over the last year and a half. This is what that situation is designed, or this is the situation that this is designed to address. As long as you are enrolled in E-Verify, it's now very easy to verify the I-9 form remotely. You can do that over the internet on a Zoom call. The specific instructions are on the form itself. So overall, good change, but be mindful that we do need to start using the new forms. So what are the takeaways of the federal legislative update? Well, number one, new federal legislation is unlikely this year. We might see new regulation, meaning regulation of currently existing laws, but it's unlikely that we will see new laws being enacted. Because of how recently, frankly, all of those laws that we just covered have been enacted, but specifically the Pregnant Workers Fairness Act and the Pump Act, those were the two most recent ones that went into effect. Be sure that your workplace posters are up to date. If you have ever been subjected to an audit by the Department of Labor, which if you haven't, I'm more than happy to describe the complete process for you. But for purposes of today, let me just tell you what the very first step in a Department of Labor audit is. Once you've been served with the initial letter saying, hey, we're the Department of Labor, we're coming on site next Tuesday to take a look around. We'd like you to have your time and pay records ready. We want you to have your FMLA paperwork, et cetera, et cetera. The first thing the investigator will do after handing you his or her business card and showing the badge will be to ask to see the workplace posters. And what they're looking for is to make sure that you have the current versions up. The Department of Labor's Wage and Hour Division specifically enforces two federal laws. One is the Fair Labor Standards Act. The other is the Family and Medical Leave Act. They will look for those two specific laws on your poster if you use the 6-in-1 or the 8-in-1 poster. And be cautious because the Department of Labor's FMLA poster expired last year and was replaced. Substantively, I think it's really the same poster. There's not really much new, if any, new information that's included in there. But be mindful, though, that the Department of Labor does have a new one. And if you are audited, that will be the first thing that the Department of Labor investigator looks for. So if you haven't updated your 6-in-1 posters for 2024 yet, now's a good time to do so. Don't wait till the end of the year. I would go ahead and do that now. Then obviously download and use the current I-9 form. We don't want anybody to be out of compliance for using the old one. All right, let's switch gears and talk about the Florida legislative update. What has been going on in the state of Florida over the last year? Well, you might have noticed that the governor of Florida has not been in Florida for much of the last year. Governor DeSantis was out on the campaign trail running for president, and consequently, there was not a whole lot of state legislation pertaining to workplace laws that was passed. Unlike a year prior to that, or 2 years prior to that, where there was a significant amount of legislation passed, virtually all of which is still in the court system, and some has been stricken down, some has not. But what's happened over the last year? Well, what we've seen was last July, the mandatory use of E-Verify law went into effect. That law basically required all Florida employers with 25 or more employees to use federal E-Verify to determine if employees were eligible to work in the United States. The penalties for failing to do so, though, did not kick in at that time. Rather, the penalties will go into effect this July 1st. So July 1 of 2024, if you are an employer with 25 or more employees, and you fail to comply with the E-Verify requirements, you'll be given 30 days to correct any non-compliance, but thereafter, there will be a $1,000 per day fine if there are 3 or more violations found in a 24-month period. So in other words, you really have to try hard to violate this law before being penalized, but be mindful that the penalty phase has now begun or will begin on July 1st. The more significant concern that I would have is that violations can also result in the suspension or revocation of business licenses or permits. This particular provision of the penalty phase of the law does not require or provide for the 3 strikes rule within the 24 months. That only applies to the $1,000 a day fine. In theory, a single violation could result in the suspension or the revocation of a business license. So there is incentive to be sure that you're complying with the law. The lenience that I mentioned earlier only applies to the penalties. And then the big change would be to the child labor laws in Florida. You may be aware, if you have minors, meaning those under the age of 18 working, that Florida law is in fact more stringent than federal law when it comes to child labor. Specifically, the child labor laws dictate things like how many hours a week a minor can work, how many consecutive days they can work, how many hours they can work on a school day or a day before school, how frequently they must be given meal periods or other breaks, and then, of course, what types of occupations they are not permitted to engage in. 14 and 15-year-olds cannot engage in hazardous occupations. The 16 and 17-year-olds get a little more leeway, but still you can't have minor employees operating, heavy machinery or sharp cutting tools, and a variety of other different hazardous job roles. Well, specifically, the change to Florida law pertains to 16 and 17-year-olds and the number of hours that they're permitted to work and when they are permitted to work. House Bill 49 was signed in March last month. After significant revision, there was some controversy over an earlier version of the bill that really gave free rein to 16 and 17-year-olds to work an almost unlimited number of hours without parental knowledge or permission. And the legislature ended up rolling back that provision. Just so you know what the law used to be as to what it is now, previously 16 and 17-year-olds couldn't work more than 8 hours when they had classes the next day. So on a Sunday or a holiday, they can't work more than 8 hours. Likewise, 16 and 17-year-olds could not work more than 30 hours in a week when school was in session. So during summer vacation, this rule didn't apply. During spring break, during the Christmas holiday, they could work more than 30. But if school is in session, 30 was the limit. Now, under the new law, which has been signed, which goes into effect July 1st, 16 and 17-year-olds can work more than 8 hours on a Sunday or on a holiday preceding a school day. They can work more than 30 hours in a school week as long as they have parental permission to do so. That was the big compromise to get the bill passed. Additionally, 16 and 17-year-olds can work more than 6 consecutive days. Previously, the law was that 16 and 17-year-olds could not. They needed to have at least 1 day off per week, but that requirement has been repealed under HB 49. So again, this law goes into effect July 1st. I don't know that many of you have minors who are working for you. If you do, of course, be sure that you're in compliance with those child labor regulations. If you are uncertain as to what those regulations are, if I've said anything that made you say, I wonder if we're having somebody do that. I use the fairly common example of a mom and pop pizza shop, right? Where they have the kid or the kids working and they're using the pizza cutter to slice the pizza in the back room. Well, that's possibly a child labor violation because they're using a sharp instrument. If you have any questions about what those requirements are, either send me an email. I'll send you the regulations, or you can go on the Department of Business and Professional Regulations website. They have a very good handy booklet, essentially, for employers that go over what the child labor laws are. All right, let me shift gears and talk about what's going on in some other states. These are not federal laws. These laws do not apply to Florida employers, but some might apply to out-of-state employees working for Florida employers. What we have seen over the last year or 2 years are more and more states enacting paid sick leave laws. Currently, we're up to 17 states plus the District of Columbia that require employers of varying sizes to provide some amount of paid sick time based on how many hours the employee works. I've given one example here. Typically, the employees are entitled to 1 hour of paid sick time for every 30 hours worked, capped at 40 hours. That doesn't roll over from year to year, or at least nothing more than the 40 would roll over or accrue. However, I will give you this caveat. That is not necessarily what the requirements are in each of those jurisdictions. In fact, if you have employees in California, be mindful that there's not only a state law requiring paid sick leave, but various municipalities like Los Angeles, San Francisco, Berkeley, even some unincorporated areas have their own ordinances that require more sick leave than the state law requires. So be cautious that this is, subject to variance from jurisdiction to jurisdiction in terms of the rate of accrual, the caps, and even employer coverage. What you should be mindful of is that if you end up with an employee working remotely from one of these jurisdictions, you should read that statute or ordinance very carefully to determine whether or not the employee is entitled to that paid sick leave. In most of the ordinances and statutes that I've read, I interpret them to mean that as long as the employee physically is located in that jurisdiction, regardless of where the employer is, and regardless of whether the employer has other employees in that jurisdiction, the employee is entitled to the paid sick leave provisions there. So anyway, this could be different from jurisdiction to jurisdiction. Again, I would just either consult with our friend the internet to get the actual text, or consult with a lawyer to find out what the requirements are. So again, even though there's no federal or state requirement currently, and candidly, I do not see Florida in the near future enacting any sort of paid sick law. I mean, could certainly change if the makeup of the legislature changes, but I don't see it happening in the near future. Be mindful that these laws could apply to remote employees. The other main statutes that we've been seeing passed in other jurisdictions are what they call salary and pay transparency laws or ordinances. Generally speaking, what those laws require is that if you post for a new position that will be filled by somebody in that jurisdiction, you must post what the salary range is for the position, or that you are prevented from asking the employee either what they're looking for or what their last salary was. And the purpose of these laws is to advance the concept of equal pay for equal work. Traditionally, females would say, and it would be true, of course, that, my last salary was lower than a comparable male employee's last salary. Therefore, if the employer is going to base your offer on what you were making previously by bumping it up $5,000 from whatever the number was, then in theory, the inequity would continue in perpetuity. So the purpose of having to advertise what the salary range is, or to prohibit those types of questions, of course, is to advance to the point where there's no inequity among the genders as to compensation. I've listed some of the big jurisdictions here that have enacted the ordinances: New York City, Westchester County, California, Washington, and Colorado have all enacted those. There are more coming down the pipeline. I'll tell you that there are some other bills in state legislatures across the country. The two takeaways that I would recommend here would be, number one, be mindful of the advertising requirements if the job is definitely located in another jurisdiction. So if you are a multi-job site employer and you have a plant in New York City that you are advertising for, be sure that your HR person is knowledgeable about what the requirements are in New York City. When it comes to remote workers, Colorado has addressed this head on. The other states, not so much. It's less clear whether you would need to comply with the advertising requirements in those other states for remote workers. But in Colorado, here's the rule. If you have ever employed one employee in Colorado, including a remote worker, you are covered by the act. Once their act applies, employers must comply with the act's requirements when advertising for not only any position that is located in Colorado, but also any position that could be performed remotely. Let's assume, for the sake of argument, you are a Florida employer. You previously had somebody working for you out in Colorado, maybe remotely. You're covered by the act now. 2 years later, that employee's long gone. You haven't had anybody in Colorado for quite a while. You're about to post a position that can be done remotely. You must comply with Colorado law in your advertisement, meaning you must post what the salary range would be. You're prohibited from asking, hey, what was your last salary at your previous job? I suspect more and more jurisdictions will take the approach that Colorado has taken. So be mindful of this. You may need to consult with Myra, with me, with the internet about, hey, what's the current state of the salary and pay transparency laws? We're about to post a position that could be performed remotely. And I remember Keith told us during the labor and employment law update that we need to be concerned about what those other state laws are. All right, shifting gears now to the federal executive agencies, the Department of Labor, the Equal Employment Opportunity Commission, the National Labor Relations Board, and we don't have their logo up there, but OSHA, the Occupational Safety and Health Administration. They are all far more active than the legislative bodies, either in Congress or the Florida legislature. The NLRB in particular, over the last year, since the last time we spoke, has implemented or issued a few board decisions pertaining to some items that are, well, fairly common that most employers have and now need to review and potentially revise. The first has to do with severance agreements that contain confidentiality or non-solicitation provisions. Now, I need to tee this up by discussing Section 7 of the National Labor Relations Act. I know some of you out there have turned my discussion of protected concerted activities into a drinking game, and now would be the time. Get your coffee, your espresso, whatever beverage of your choice, and every time Keith mentions protected concerted activities, have a sip. This is the first time. Section 7 of the National Labor Relations Act provides that employees are guaranteed the right to self-organization, to form, join, or assist labor organizations, meaning unions, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. The last few words that I mentioned here are what give employees a wide variety of rights, whether they are in a union or not in a union. Again, they have the right to engage in concerted activities for their mutual aid or protection. And what do we call those activities? Protected concerted activities, or PCA for short. Now, Section 8A1 of the Act makes it an unfair labor practice for an employer to interfere with, to restrain, or coerce employees in the exercise of rights guaranteed in Section 7 of the Act. Traditionally, we would run into this issue with handbook policies, with workplace rules. In fact, there is a library of National Labor Relations Board decisions pertaining to whether or not a particular handbook policy or workplace rule violates Section 7. Hold that thought. We'll get to that in just a minute. But first, what the NLRB did last year was to issue a decision pertaining to severance agreements that were provided to employees who were being laid off. And specifically what happened there was that the non-disparagement and confidentiality provisions that were in those severance agreements was determined by the board to be a violation of Section 7. The board's rationale was that, hey, employees have the right to discuss amongst themselves things like terms and conditions of employment, or how bad they are, or what happened at work that led up to me being given this particular severance agreement. Likewise, the board has long held that employees have the right to say disparaging things about supervisors or about the company in general, so long as that disparagement doesn't rise to the level of defamation, let's say, or even higher standard, knowingly false statements, et cetera, et cetera. So anyway, the case that came out prohibits the employer from even asking for a broad confidentiality or non-disparagement provision in a severance agreement. Now, you can still demand confidentiality of things like your trade secrets. You can demand confidentiality of things like your customer list. What you cannot demand confidentiality of, though, is any term or condition of employment, anything that has to do with the workplace, with even the termination of employment of employees. And likewise, of course, you can't demand non-disparagement. Now, a word to be mindful of is that the National Labor Relations Act only affords these protections to non-supervisory employees. If this is a supervisory employee, this law doesn't apply. You can still demand confidentiality. You can still demand a non-disparagement agreement in a severance agreement that you have with a supervisor level employee. There are a few questions left unanswered following this board's decision, though. And the questions that are left unanswered are, well, does this apply to settlement agreements as well as severance agreements? I don't know. There has not been a board decision that's addressed that squarely. I would guess the answer to be yes. And in fact, in some settlement negotiations I've had, this has become an issue. So be mindful that not only with severance, but also potentially settlement agreements, you might not be able to get a broad confidentiality clause as part of that settlement agreement. So shifting to handbooks, which I mentioned earlier is the traditional forum in which we see disputes over Section 7 rights arise. There was a rather significant change in the law last summer here as well. Let me give you a very short history of how the NLRB has applied Section 7 to employee handbook policies. And if you've been a repeat customer, at this particular labor and employment law update over the years, you've probably seen this in real time, what the changes have been, because we've discussed them pretty frequently. From 2004 to 2017, the board standard for evaluating whether a handbook policy was lawful or unlawful was to determine whether the policy would reasonably tend to chill employees from exercising their rights under Section 7. So I'll give you a kind of textbook example of a handbook policy that clearly violates the law. One that clearly violates the law would be, hey, you can't discuss your compensation with other employees. Compensation information is confidential. Don't discuss it. Clearly unlawful right there. Maybe not so clear would be this. Employees are prohibited from taking photos within the workplace. That was actually a case that went before the board. In fact, a few times in various settings, in the settings of a restaurant, in the settings of a hospital, and in those particular cases, the board found that the no photos in the workplace policy violated employees' Section 7 rights, their rights to engage in protected concerted activities. Why? The board's theory was, well, employees might want to take photos of things in the restaurant, of things in the hospital. In the restaurant, maybe they see that the food is gone bad and is spoiling, and workers are made to prepare and serve food that's going to make the customer sick, and an employee might want to snap a photo of that so they can talk to other employees or go to the health board, which is also protected concerted activity, or go to the media, also protected concerted activity. So this rule would tend to chill an employee from exercising their rights under Section 7. In the hospital setting, what if the patient care is poor? What if the working conditions are poor and we need to snap a photo of the dirty linens that the employees are being made to put on the hospital beds? Same rationale. Employees have the right to discuss this amongst themselves. They have the right to go to the media. They have the right to post it on social media. They have the right to do a number of things with those photos, and therefore a seemingly innocuous handbook policy, no photos in the workplace, was deemed unlawful up until late 2017. In late 2017, the NLRB issued a decision in a case that's called the Boeing Company case. By the way, NLRB decisions do not have the traditional heading you would see in a lawsuit like Jones versus Smith. There's no versus, it's just the employer's name. The employer is being dragged in front of the National Labor Relations Board, so theirs is the only name that you'll see on an NLRB case. So in the Boeing case, oddly enough, the very same policy was before the board. No photos in the workplace. The board decides that the previous standard for determining whether or not a workplace policy was unlawful should be thrown out the window, and we're going to come up with a new standard in this particular case that will apply from here on out. The standard is we're going to come up with 3 categories of workplace policies. In the first category, policies that are always going to be lawful. You know, the hypothetical situation in which this could chill employee Section 7 rights is so far-fetched that the policy's got to be considered lawful. We're not going to stretch the boundaries. At the other end of the spectrum, policies that are always going to be unlawful, which would be the don't discuss your compensation among coworkers policy. But then in the middle, there's some gray area. That's the category 2. If we were to say 1, 2, and 3, category 2 would be the ones in the middle that reasonably would tend to chill the employees' exercise of Section 7 rights. But if the employer can come up with a legitimate reason for having this policy, then that's good enough. You know, that policy will be deemed lawful. Which category did the no photos in the workplace for Boeing fall? Category 1, always lawful. Boeing argued that we are in an industry where we are constructing not only civilian, but military aircraft and hardware. And therefore, if somebody were to be taking photos in here, it could be international espionage, it could be corporate espionage. There is a legitimate and compelling reason to allow us to have this no cameras in the workplace, no photos in the workplace rule. So 2017, the standard changes completely. All of a sudden, many handbook policies that would have been unlawful prior to 2017 would now be permissible. Fast forward to last August. The NLRB again addressed what the appropriate standard is for determining whether or not an employee handbook policy is lawful or unlawful. And what the board did, which the board has a tendency to do, is to reject the current standard and go back to the previous standard, which was, again, whether the policy would reasonably tend to chill employees' exercise of their rights under Section 7. So under the standard adopted in this newest case, which is called Stericycle being, I believe, the company that implements the SteriSafe exams. If you ever work in a restaurant and you have to take the hour-long or 2-hour-long course about food safety, that's who they are. But under the new standard, here's what happens. The NLRB's general counsel, their kind of enforcement arm, can challenge a handbook rule and must prove that it would have a reasonable tendency to chill employees from exercising their rights. Is there a general counsel police officer that's going around looking at employee handbooks? No, they don't knock on your door and ask to see it. What they do, however, is if you have an unfair labor practice charge levied against you, or these days, even a charge of discrimination with the EEOC, the agency will likely ask you for a copy of the entire handbook. And somebody within the NLRB's regional office will go through that handbook and flag any policies that look to be unlawful. The general counsel then picks and chooses which policies it wants to take before an administrative law judge to try to get a ruling that the policy is unlawful because it violates Section 7. So anyway, that's how this situation could come up in the first place. So here we are. The general counsel has gotten a copy of your handbook. They think that the rule that you have in there is unlawful. They show to the administrative law judge that there's a reasonable tendency that employees would not exercise rights that they're entitled to exercise because of the policy. Then the burden shifts over to the employer. The employer can rebut the presumption that this policy is unlawful by proving that the rule advances a legitimate and substantial business interest, and that the employer is not able to advance that interest with a more narrowly tailored rule. Now, here's where we start splitting hairs. Boeing could probably show that its policy of no photos in the workplace is lawful, even under this standard. We have to prevent international espionage, corporate espionage, etc. The restaurant and the hospital, on the other hand, probably cannot establish that their no photo policy is still lawful. They do not have a legitimate and substantial business interest that overrides the public interest in food safety, in hospital safety, patient safety, etc. So where does that leave us? What's the takeaway here? Well, you know, if you revised your handbook between 2017 and 2023, there may be some policies in there that were perfectly lawful at the time, but which now would not be perfectly lawful. If there is any advantage, any silver lining to the fact that the board reverted to the previous standard, it is that we have about 13 years worth of board decisions using that standard in which we can see whether certain policies were deemed to be lawful, were deemed to be unlawful, and even in many situations, examples where the board has provided sample policies pertaining to particular subject matter and has said, this passes muster, this is okay. So if you have not had a handbook review since 2023, mid-2023, it's probably about time. And I know Myra has certainly mentioned this to many of you. In fact, I've worked with many of you on a handbook review. The good news is I have not seen all that many handbooks that require extensive revisions. I do see handbooks, though, that have policies that would be deemed illegal right now, but with a few tweaks can be brought back into compliance. If you have any questions about having your handbook reviewed, please, feel free to talk to Myra, feel free to talk to me. I'm not trying to advertise services here, but it's a relatively inexpensive fix to avoid what could be a significant problem down the road. The other issue that the NLRB has been taking a much closer look at, and again, we have some shifting case law here, is when an employer terminates or even disciplines an employee for misconduct, while at the same time, the employee is engaged in a protected concerted activity. Now, I've given a few examples of protected concerted activity, but let me give a few more. One would be when two employees go to the manager's office and says something like, hey, we're not being paid enough, you need to give us raises across the board. Or even when just one employee goes into the manager's office and says, hey, I'm speaking on behalf of all of us here, we need better pay. That's protected concerted activity. Certain engagement on social media is protected concerted activity. If one issues a post saying, hey, working for this company is really awful, who's with me? That's enough to make the activity concerted. You are inviting other employees to join in that activity. You're talking about work, that's protected activity. The same is true of conversations at work. Conversations among two employees on the assembly line could be protected concerted activity. And then something that probably not a lot of us on the call have to worry about, but picket line conduct. If you have a union and they're out picketing, That's protected concerted activity as well. So let me go back to this particular topic, which is terminating or disciplining an employee for engaging in misconduct. It's not uncommon for an employee to commit some sort of misconduct, some sort of violation of your perfectly legitimate work rules, while also engaging in protected concerted activity. So the question is, well, what is an employer entitled to do in that situation? Well, previously, the board has always taken the position that employees are entitled to a lot more latitude in their misconduct when they are engaged in protected concerted activity. For example, if during the conversation about, hey, we're not being paid enough, the employee happens to call the manager a SOB or worse, hey, that's okay under the previous board standard. What happened in 2020, forgive the typo here, the General Motors case came out in 2020 and rejected the board's traditional standards for evaluating whether misconduct amounted to a terminable offense by examining whether the misconduct happened when protected concerted activity was going on. In 2023, the board again overruled the 2020 case and went back to the previous standard. So to kind of explain what's going on here, the board has long taken the position that the protections that Section 7 affords would be meaningless were we not to take into account the realities of industrial life and the fact that disputes over wages, hours, and working conditions are among the disputes most likely to engender ill feelings and strong responses. Thus, when an employee is discharged for conduct that is part of the res gestae, or greater body of protected concerted activities, the relevant question is whether the conduct is so egregious as to take it outside the protection of the act or of such a character as to render the employee unfit for further service. So pre-General Motors 2020 case, conduct that occurred as part of the course of protected concerted activity had to be evaluated as part of that activity, not as if it occurred separately from it and in the ordinary workplace context. Let me break that down into even more colloquial terms. Frequently, I will get a phone call from a client, hey, we got a situation going on right now. Here's what happened. So-and-so and so-and-so came into the office demanding higher wages. They called me an SOB. We have a no profanity policy. Can't I fire them for that? And the answer under the old standard would be no. Their misconduct is not so bad that it amounts to a terminable offense. Their protection from engaging in protected concerted activities, think of it as there being a cloud around those activities, and the misconduct is within the cloud that's protected. Now, keying the manager's car in the parking lot, that's outside the cloud of protection. That's misconduct that's serious enough to warrant a termination. But merely using bad words, not enough. Under the General Motors standard, though, the NLRB said, wait, ignore the setting. Ignore whether or not the employee was engaging in protected concerted activity. If you would have fired this employee for this misconduct absent the protected concerted activity, you're good to go. You can do so if you have a legitimate business reason for terminating the employee. What changed in 2023 is in the Lion Elastomers LLC case, the board returned to the setting-specific standards. So the employer's motive doesn't necessarily dictate the result. So the employer, it's not enough for the employer to say, well, look, we've got a policy, we apply it uniformly across the board. We don't tolerate profanity in the workplace at all. Rather, the extent of the misconduct is the proper focus. And again, the board will allow the use of the profanity. It won't allow keying somebody's car, threatening physical violence, or things like that. But the takeaway for this is, number one, employers should recognize what activities constitute protected concerted activity. I mean, first and foremost, if you do that, you're ahead of the game. Many employers do not. Many employers think that the National Labor Relations Act applies only to unionized employers, and that simply isn't the case. It applies across the board to sub-supervisory level employees. They are guaranteed the right to engage in protected concerted activities. The other takeaway is to proceed with caution or obtain legal advice before terminating or disciplining an employee who has engaged in misconduct while also engaging in protected concerted activity. I actually already talked about the severance agreements and confidentiality provisions. The case, in case anybody's curious, is involving an employer called McLaren McComb. I think the biggest concern that I have over the case is that even asking the employee to sign that provision amounts to an unfair labor practice. So certainly be cautious. You know, these days, when I have an employer contact me and say, Keith, I need you to whip up a severance agreement, I used to ask questions along the lines of, okay, is this an employee who's under or over age 40? Remember, we've got to include Older Workers Benefits Protection Act language if they're over 40. Were they exempt or non-exempt? What's the last date of employment? Well, now I'm also asking, was the employee a supervisory level or non-supervisory level? If non-supervisory, we need to take out that confidentiality provision. We need to take out the non-disparagement provision. So, by the way, where does this leave us with respect to severance agreements and separation agreements? It seems like we have a whole host of laws that we need to be concerned about. And the answer is we do. There are many instances in which we are not able to demand some sort of broad confidentiality provision. For example, in the severance agreements with sub-supervisory employees. Remember at the beginning of this update, we talked about the Speak Out Act, where confidentiality is not permitted in the settlement of pre-dispute sexual harassment claims. And, fast forward to what I'm about to talk about here, which would be agency enforcement priorities. The EEOC announced very recently that its priority in the next several years will include focusing on overly broad waivers, releases, non-disparagement, and non-disclosure agreements. So it looks like the EEOC is throwing their hat into the ring on this particular issue as well. The takeaway here is, while there's still certainly no prohibition on entering into a severance agreement or a separation agreement, there might be some limitations on terms that up until now have been pretty standard in any type of severance or separation agreement. All right, the NLRB also announced in October of last year a final rule establishing some new criteria for determining joint employer status. Now, I fully realize that joint employer concepts probably don't apply to most of you on the call, but may apply to some, particularly if you use an PEO, a professional employer organization, such as ADP Total Source, or one of those which provides you with the employee handbook to use. You use their time clocks, etc. The joint employer concept is simply this. If there are two or more entities, each of which share some level of control over the terms and conditions of an employee's employment, then they can both be held liable. For PEOs like ADP, this really isn't much of a concern. The bigger concern would be, what if you use a staffing company that turns out to be maybe not the most reputable, and they're not paying their employees overtime, they're not paying their employees minimum wage, even though to you it looks like they are. Your contract with the staffing company is, you provide me these bodies, I will give you $15 an hour for every hour they work and time and a half for hours beyond 40. But lo and behold, after a Department of Labor audit, it turns out that the staffing company was not paying the employees properly. If you, the user employer, had any degree of control over essential terms and conditions of employment, such as their hours of work, who gets hired, who gets fired, who gets disciplined, are your supervisors supervising them, are your supervisors giving them direction, you can be jointly and severally liable with that staffing company, even though you had no knowledge that the violations were going on. So take away from this, it's much easier now to be considered a joint employer than maybe in previous years. All right, let's shift gears one more time and talk about what the enforcement priorities are for federal agencies in the coming year and coming years. Every agency implements their enforcement policies on at least an annual basis, and these are available publicly. You can go online and Google something along the lines of what are the NLRB's enforcement priorities. You will see a link to a memo from the general counsel saying this is what we are going to do this year. We are going to challenge the following types of handbook policies. We are going to challenge joint employment issues. The EEOC actually has a 5-year plan that was just implemented. It begins in 2024, runs through 2028, I believe, because 2024 is inclusive as year one. But here's what the EEOC is going to be looking at over the next 5 years. They'll be focusing on whether employers are using qualification standards and inflexible policies or practices that discriminate against individuals with disabilities. Let me give you an example of the type of qualification standard that they might be challenging. Let's say you operate a warehouse. Your employees need to frequently be lifting, bending, stooping, etc. You have everybody, sign off on a document that says I'm capable of lifting more than 50 pounds at a time. Well, the EEOC might say, well, wait a minute here, if this would disqualify somebody with a disability, but there's an accommodation that would enable them to perform this job, then we've got a problem here. This is discriminatory against individuals with disabilities. That's just one of many examples. As we move into more and more technologically enhanced workplaces, what we've seen is a big uptick in claims where persons with disabilities are alleging that the software or the platform, the operating system that's used by the employer does not have functions that allow me to be able to use it and to perform as any other person could. Another topic that you may have seen, particularly if you operate a place of public accommodation like a restaurant or a hotel, is a wave of lawsuits over the last many years pertaining to your website and whether or not the website is accessible to persons with disabilities. For example, persons who are vision impaired. Is there something on your website that has a voice or sound activation that will allow them to be able to use the website the way that any other member of the public would? Going back to the EEOC's 5-year plan, another enforcement priority is to protect workers affected by pregnancy, childbirth, or related medical conditions. We have, as I mentioned earlier, seen just yesterday that the EEOC announced they are publishing the final regulations on the Pregnant Workers Fairness Act this coming Friday. Another enforcement priority is to address discrimination that's influenced by or arising as backlash in response to local, national, or global events, including discriminatory bias arising as a result of recurring historical prejudices. And finally, the EEOC is placing a priority on advancing equal pay for all workers. As I mentioned, there is no federal statute regarding pay transparency, but one of the ways that the federal or national government can try to address this is through agency action. So we'll see exactly what the EEOC means by this. I don't think that they have the authority to enact any sort of nationwide pay transparency regulation or prohibition. What they do have the ability to do, though, is to go after the systemic offenders, the ones who they can prove are paying females less than they're paying males for the same work. They can drag them into court. They can bring the equivalent of a class action where all affected workers would be afforded relief if the EEOC prevails. So we'll see. We'll see what happens in the next few years in connection with this particular priority. OSHA, the Occupational Safety and Health Administration, over the last couple of years has become increasingly aggressive in its enhanced compliance agreements, which if you've ever had an OSHA investigation where they've concluded there was some sort of safety violation, what OSHA will do is initially implement a fine, usually a pretty hefty one, but then give you the opportunity to negotiate that fine down. In exchange for paying less money, you would be required to enter into an enhanced compliance agreement. What do I mean by enhanced? Well, it means that the employers are required to agree to a wide variety of steps to improve safety and avoid citations, such as, these are just examples, the EEOC might insist that you implement some sort of safety advisory group, or that you create some audit program or training to make sure that this type of hazard doesn't repeat itself. It might require that you hire safety professionals if you are in, for example, the construction industry with a large number of roofers, and it turns out your roofers don't use fall prevention equipment or things like that. The EEOC might say you need to retain an expert to go around, do an assessment, and provide recommendations as to how you can come into compliance with the law. Additionally, believe it or not, criminal penalties are possible under OSHA when an employee is killed as a result of an employer's willful violation of an OSHA standard, or where an employer lies to an OSHA inspector. Both of these are certainly very, very concerning. Obviously, nobody would ever advocate that an employer lie to an OSHA inspector, but I'll give you an example of an employee being killed. Let's say they work on a construction site. They are working on a second floor indoor unit. The staircase has not been put in yet, so they're using a ladder to come up to the big opening in the floor where the stairwell will eventually be. The employer fails to cover it up when it's not being used, and as a result, somebody falls through it. They end up, unfortunately, dying when they fall. The question as to whether or not this was a willful violation, I think, is a fine line. You could very easily be found to be willfully violating by not having somebody standing there with a sheet of plywood to cover up the hole in the floor immediately once somebody gets off that ladder. I mean, this is just a thing that I think is rife for additional litigation. Of course, many of you are in a more white-collar atmosphere where OSHA violations are unlikely, to say the least. But for those that are in a more industrialized setting, certainly be mindful that OSHA is ramping up its efforts for compliance. Finally, what I find to be a fairly terrifying strategy by OSHA is to attempt to pierce the corporate veil where the employer is a repeat offender. And by piercing the corporate veil, that's a legal term that basically means to remove the corporate protections. The reason that companies incorporate is to protect their shareholders from personal liability. Well, there are situations where a court will say, no, you treat this corporation as your own personal enterprise. You use the operating account as your own piggy bank. You commingle your personal funds and your corporate funds. There's no separation of the corporate identity from the person who owns it. We're going to remove those corporate protections, and you, individual person who owns this company or all of its shareholders, could be held individually liable. OSHA's penalties have also increased. Last year we discussed that they increased rather significantly. This year they've increased, not quite as greatly as they did last year when they went up over 1,000%. This year there's a much lower increase, but still an increase nonetheless. For other than serious violations or serious violations, you could be assessed a penalty of $16,131. And frequently, that is the amount that I see assessed for these types of violations. And then OSHA will negotiate down from there, but get some concessions from the employer, such as those enhanced compliance agreements. For willful violations, typically meaning I knew what the law was or I was aware of this safety hazard and I didn't do enough to prevent employees from being injured, or for repeat violations, the citation per violation, $161.323. Let me go back to the example of the roofers who aren't using the fall prevention equipment, like the pulleys and the straps and whatnot. Let's say OSHA goes out and finds that you're not doing that. You've got 10 guys on the roof or 10 workers on the roof. You'll be assessed a violation of $16,131 times 10. So that's $161,000 for your first time violation. For your second time violation, 10 employees, none of whom are using the fall prevention equipment, that's 10 violations at $161,323. So the amounts rack up quickly, although OSHA will tell you we're not trying to put anybody out of business. The reality is employers cannot afford to be engaged in violations like this, particularly when one or more employees would be affected. So with that said, it has been an absolute pleasure today being here for the Labor and Employment Update. This update may be a little shorter than others, but that would be a function of the fact that there simply haven't been as many employment laws passed over the last year as we have in a typical year. I know that we have invited anybody with questions to type them into the comment box, but at this point, I think we'll open things up to any questions that if you'd like to unmute yourself, you could do that. So let me turn things over to Myra and Luann at this point.
Thanks so much, Keith. Again, if anyone has any questions, feel free to type those in the chat or unmute yourself at this point. Keith, currently I don't see anything in the chat, so we'll wrap it up from here. Should any of you come up with any questions throughout the day, as always, feel free to call myself or Keith. We appreciate your time. Thank you guys so much. Anyone who needs the SHRM credits, just let us know and we'll get those out to you. Have a great day.